I was told there's something in 1C, there's something next door, there's something in here that is of interest to lots of folks. I'm a little more focused on all the murder cases, but so will you be handling all of the bond hearings? There's one add-on that is sex crime. Okay, I saw Ms. Clark kind of briefly in the courtroom.
Sure, there's a couple. I think there's 3 defendants who have murder counts, but also the cat case, so she'll be handling those as well.
Okay, got it. Yeah, there's a couple whose kid OD. She'll do that. Okay, and then the add-on with, I think that's Mr. Tevis is handling that. Okay. Is she coming back here? All right. And on the defense side, sir, do you have the good fortune of handling all of the appointed cases?
Your Honor, as far as I know, I'm here for just Roger Powell.
Just one?
Yes.
Okay.
And I'm not sure this.
Hey, folks, and welcome to Hearing Day. Today will be the bond hearing of one of them, case dismissed or not on the and as far as I know, there will also be a hearing regarding the remaining 5 today, or at least an update hearing. Still waiting for my coffee to be ready. Slightly hungover, and all right, I will let this play on while I fetch my coffee. Okay. Thank you for being here, folks. Thank you.
Probably brought up here. It's my understanding he's going to custody there.
Okay, well, that'll streamline that one. Okay, and you are?
Attorney Gear Sergeant.
Okay. But that's the only one you've got?
Yes.
Okay. Will Mr. Rao be able to stay? Will you be able to stay here if Mr. Abate has to go to 1C, or you guys are there?
I'm sure we can tag him.
Okay.
Yeah, he can stay. I don't know later. That's what the case.
Okay. We'll see. Currently, we have no defendants.
Yeah. Yeah.
Mr. Mursajan, do you have a colleague who will be covering? We have 10 bond hearings, and in reviewing them last night, a number of them look like they would be appointed counsel. I know there's going to be one conflict issue because it's co-defendants, but I'm surprised you have only one, and you're lucky if that person's not here.
To my knowledge, Your Honor, I haven't spoken with any other attorneys about being here to bonding, but I can reach out. And
Okay. Great. Who typically covers this calendar?
We just have the clients are assigned to us, based on when they had their first appearance.
Okay.
So, I would have had, Mr. Powell today, so
Do you have it already? I have, but I don't have it together.
Mr. Beatty hired private counsel, as my understanding, so I was going to hear from Mr. Powell. And the other, defendants should have their public defenders as they were assigned to them.
Okay, yeah, if you do a little outreach, that would be great. All right, are there any attorneys here for bond hearings for someone whose name is not Kendrick? Yes, ma'am, you are here for whom?
I have Carl Washington and Darrell Eric Wood.
So Carl Washington's been indicted and assigned to Judge Leffridge, so we will not be hearing bond for Mr. Washington today. What was the other one?
Darrell
Darrell Williams, I got that one. And you are?
Stillwell.
Can you say your last name again?
Isola.
Isola?
Isola.
How would you spell that?
I-N-I-E-L-L.
Okay, so once Mr. Williams is up, we'll try to do that one. Judge Leffridge. So that won't be heard today. That's just, he's been indicted. And so any issues or questions about bond will be covered by Judge Leffridge, to whom his case was assigned. So I don't even think he was brought over today. He may have been, but I won't be addressing bond because it's now assigned to a judge. Good morning, Ms. Clark.
Morning, Your Honor.
So you'll be handling the bond hearing for, assuming we get lawyers, for Kuykendall and McCaslin,
Yes, Your Honor.
as well as Mr. Tevis's client.
Tyreek
Yes.
Robinson.
Yeah.
All right. Coffee ready and stuff. And as you might see, on the top of the chat on YouTube is Legal Vice's channel. If you missed it, he passed away Sunday, and we all found out yesterday. We are trying to get him to 100,000 subscribers, so his family can get that play button that he fought so hard to get. He is currently at just over 86,000. So if you haven't subscribed to him yet, please do. Please do.
Pardon me?
I didn't receive a calendar for this date. I don't know that because I looked up my concept, Odyssey.
Uh-oh.
So if I get a calendar and forward that to Woods.
Okay, let me get you a calendar. Ms. Nelson, can you text me to whom you sent the presiding bond calendar on the public defender side? Because it sounded like it might not have gotten over there.
It went to our team, and so it
Meaning-
didn't go to any private attorney. I mean, it didn't go to the public defender's main office. It went to our team.
Meaning it went to Ms. Rios and Ms. Wood.
Correct.
Okay, I'll print you one.
And additionally,
I got an extra copy.
Of the bond calendar?
Yeah.
Great, here it comes.
additionally, I did not file a bond motion for this hearing today, so I also need to see why other public defender attorneys are not aware or not here.
Huh,
This
well, we shouldn't be calendaring things where there aren't bond motions. We're gonna need to work on our process.
because my client has only been in custody for about 20 days and haven't even had a hearing yet.
Well, that's what all these are, though. These are the ones where there was a bond deferral. So at first appearance, because of your client's charges, murder, and all these other folks, with one exception where it's a child sex offense or a rape or something, they're all murder cases. And so they never got a crack at a bond hearing. And so we automatically put them on these calendars. But you can say no thank you at this point. There's not a mandatory bond hearing.
Yes, sir, that was my plan well, not to withdraw the motion, but say we're not ready for a bond hearing this time.
Okay.
On this house, yeah.
Okay,
I will reach out to the other attorneys and figure out.
okay. So I should take Powell off because you don't want to go forward with bond today. It'll stay with me. It's until indicted. Bond hearing will be here. So if you want to defer the bond hearing to another day, that's good to know. I just want to make that notation.
Yes, sir, that's enough.
Okay, thanks. Yeah. But that may make it go more quickly. Right. Okay.
Hey, Jan. Loves you too.
All right, so if there was anyone here for Mr. Powell and the deceased in that case is Mr. Woods, we're not going forward with that hearing today. And we'll see what other announcements we get.
Wow, you're looking to figure out what, I forget the attorney's name, that seems to be the running theme of these, the positions today. There's no bond motions filed, like in, for example, Mr. Drinker, there's no bond motion.
First, when someone enters an appearance, I don't know what's triggering it, but we're gonna need to rethink our approach and just slapping everything down that got deferred for a hearing. And I think the default is you could not have had a bond hearing even if you asked for one, if you're Mr. Drinker, just using that as an example, because of the charges. Mr. Drinker, there are two decedents? Did I read that? Okay. So, but that may explain why there aren't colleagues of Mr. Mursad here that they weren't planning on arguing bond at this point. That was streamlined today.
Probably why there isn't an attorney listed on the calendar either. There's
Yeah.
a lot of them there.
That one we can do. He's one of the Powells, is Roderick Powell's your client?
Yes, sir.
Do you want to talk to him or?
I can speak to everyone.
We're speaking, so he can go back down Roderick Powell. And we have a lawyer for Daryl Williams. Daryl Williams is here. Okay, so we can do that. Daryl Williams and Robinson Baker are the ones that are ready to go.
What we are waiting for is Diamante Kendrick, also known as Jack Gotti.
Do you have one of the? You're just a hanger on.
I'm a
That's what I thought. Okay. You got nothing to do these days.
Right, no, I'm actually next door. I'm next door, but yes, I'm looking for things to do.
Okay. I got some
Good to see you
things.
guys.
Yeah, let me know. Could do some trials next year.
Can I talk for a second?
Yeah.
And if things go, because most of these are happening simultaneously with Jack Gotti, Shannon, Stillwell, and the remaining 5. And I'm following Joseph Papp and his co-workers, Rosie Mannins and Shadi Abasaid. Because in Judge McBurney's courtroom, which we are looking at here, is the bond hearing for Diamante Kendrick. And then you have Judge Whitaker's courtroom with the remaining YSL defendants. That will start in 6 minutes. And in Judge Edwards' courtroom is the Shannon Stillwell hearing. So I will follow those as well, but for me, this one, his bond has priority right now, Jack Gotti's, and then I will tune into the YSL and catch up there, the remaining 5, and then I will update you on Shannon Stillwell, because I don't think Judge Edwards allows cameras. All right, let's keep going.
This might have been after your time. Did you ever go to University of South Carolina for the Trial Advocacy Center over there as a AUSA?
Yeah, a lot. That was where all our trainings were.
Right. I went to school there, and last week, Victoria, she was a mock judge.
Max Shaw.
They have the district court judges go down and help train. So I got to go back down there, and that was always on campus when I was there.
Yeah.
Towards the end of my time there, it was on campus, but I never really took note of what it was. It was just some fancy building that I knew nothing about.
Nice.
Yeah. So
Yeah, because the residences are there, and there's a
right.
cafeteria.
Oh, don't do that. No.
And then all the classrooms.
Well, I heard the residences aren't that great. They put us up in a hotel right next to it called the Graduate. And it was a good time. So I got to take Hollis down and show them where I went to school and
Good.
everything.
Excellent.
So,
Family event.
Yep.
We've got Baker. Okay. Mr. Tevis, you ready to go? Ms. Clark, we're going to do Mr. Robinson Baker.
There's a lot of people tuning into this right now.
We got.
Stop doing that. Why is it a world of two?
Considered when establishing bond, but I would like to just
For bond and what will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf.
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is
Oh, Jesus Christ, what's going on?
a good candidate for bond and what that bond should look like.
Judge, you of all people,
freak's sake.
Are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building that I want to argue against the backdrop of that. So first of all, everybody's famous case in Georgia, Aala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303 Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm, and detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail, because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done, the state will rely heavily on the facts because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation and also worked for FedEx, making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control, which does construction projects where they, divert traffic and make sure that that's a safe environment. He has a history of employment here in Georgia. He has strong ties here in Georgia. His parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because the media case, they're not letting us in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle. Not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies. On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to the court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. You know, I know your background, having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice is to set a high bond, which in all honesty is, enriching the bonding company, but I don't think that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bond?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
And
that.
that's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so I think there was one that was a
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but
Yeah.
the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank you.
Ms. Clark. Oh, Ms. Clark, before you go, you will come on. I could tell you good morning. Ms. Jackson, how are you doing?
Oh, I'm great. How are you, Your Honor?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it, Your Honor.
Great, if you'd share that, please.
Yes, sir. He has 4 cycles. The last arrest was August the 24th, 2021 in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have 1 prior misdemeanor conviction in 2022 in Cobb County for a non-fingerprintable offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't going to be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation out of Cobb in light of this situation?
Good morning, Your Honor. Yes, Your Honor, there is an active
I can't hear you. It's odd. You're not muted.
warrant
but
at this
can't hear
time.
you.
Your Honor? Can you hear me? Your Honor?
Seems like they are having boomer moments
Can you hear
in
me,
the
Your Honor?
courtroom.
Other people can hear you. That's peculiar. Some of my staff said they could hear you, but it's not coming into the courtroom. I don't know what that deal is.
He is on
Well, if you
active
just want to type in
probation.
the chat, whether there's a warrant, I'll relay that. He is not yet. He does have a warrant. Okay, thank you. That's what I needed to know. Appreciate it. Ms. Clark.
Good morning, Your Honor.
Good morning.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself in. After a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So
Now,
that
Mr.
is-
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that, that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's
Okay.
not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the Aala Factors. Your Honor, the state wants to bring the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that, bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. There's a young lady, Kim Yee, who actually was a friend.
Okay, it seems to be a while before the Kendrick bond hearing starts. And the hearing for the remaining 5 in the YSL-Trial have started. So I'll be switching over to that one. Here it is.
You have apparently filed into Mr. Effinger's case, Rule 22. It has never gone to our public information office, and if you look on our website, there are very clear instructions about how you're supposed to handle Rule 22. And you're not supposed to file it in the case, and you're not supposed to send it to chambers. You're supposed to.
Can you, very low sound. Okay, let me get the boosters.
But I mean, I am aware of it, so just in the future, if you can try to do it the correct way.
I think my colleague filed that one, but.
Okay, well, yeah, you can blame it on your colleague, that's fine. But anyway, in terms of, I do not mind if you have and I don't even know if notice went to anybody or if anybody is gonna have any objection, that's one of the reasons why it needs to be done a particular way. So I'll have to find out when we have everybody here, but assuming no objection, you certainly may use your laptop. And if y'all have a still photographer ever, that's welcome. Any other kind of like feed can just go through the pooled camera. All right. So we'll just wait until we get everybody before we get started. Other than that, I'll rearrange my.
Oh, of course, this hearing that started, now we're looking at the seal again. Let's go ask what network is providing this feed. Well, the feed in Judge Whitaker's is local. It's a local court feed. I'm not sure. Am I very low? Audio. Better? Is this better? Checking. Is this better? Okay, that's better. Okay. Okay, so 3 things happens today. It is bond hearing for Jack Gotti for charges he got while in jail. He was in, I believe, 2 or 3 fights. Then today also what's happening is the Shannon Stillwell, they are moving for dismissal of his remaining charges. And we have this, which is a hearing regarding the remaining 5 defendants in the YSL-Trial that is scheduled for February 24th so far. The claim from the prosecution so far is that they plan to go ahead. Doug Weinstein says he would be surprised. Well, he didn't say he would be surprised, but he do not think that will go to trial. I don't know. So, as I told you guys, in June of last year, gavel to gavel in the YSL case. Fox 511 alive. Yeah, I mean, I have those as... let's see here. The Fox 5 Atlanta is showing the same picture as I do. And oh, okay, let's switch up again. Here's the Shannon Stillwell hearing.
Max chart is he present today. Right in position 3, it lists Attorney Bumpus. Is that?
I should be the attorney of record of all 3.
I thought so, but I'm just, what's a
All right.
misunderstanding?
So now,
and that's fine. And I appreciate the court making time for us, Your Honor. We will have a negotiated plea to present to the court this morning.
Hold on one second, I need to get the ADA on the record.
Morning, Your Honor. Chris Sterling, now for the state of judicial efficiency. I'll handle all three matters.
All right, thank you.
It seems
And
like
Your Honor, I do believe that I need to sign some indictments in preparation of the plea. Do we have those in court?
Yes.
I thought I heard they had negotiated a plea deal for his remaining charges. So, if approved by court, then Shannon Stillwell is done. He is...
So you need a few minutes, we can do something else?
Yes, Your Honor.
All right, that's fine.
Thank you.
And it's a pause here as well. Now I'm sticking to this
We'll
one.
move to the all-purpose criminal calendar. Position number 1, indictment 22 SC 182298, Denise Dillard. All right, we'll hold. Position number 2, indictment 22 SC 182298, Russell Green.
Judge, he's here. I'm not sure if they're still gatekeeping.
All right, position number 3, indictment.
Yeah, it seems like, if I heard Mr. Short correctly, that it is a negotiated deal regarding Shannon Stillwell's remaining charges, which I assume will mean that Shannon Stillwell will walk out of court, well, back to jail, get the process, the paperwork, and then he's a free man. And Shannon and Kayla can finally go on their honeymoon. I assume within the Georgia borders, but I have no idea how that works, what his conditions might be. I have no idea. Good morning again, everybody. Thank you all for being here. If you're wondering why I have on the top of the YouTube chat, that's Legal Voices channel. Legal Voices, Jeff, sadly passed away Sunday, unexpectedly. And we are trying to get his channel to 100,000 subscribers. The rest of the law tubes. And so if you haven't subscribed to him yet, please do, so his family can get the YouTube play button. So more regarding that, this little area of LawTube, which is Jeff and all his friends, we are planning a joint stream on the 27th. Because that, sadly, it needs to fit as many as possible schedule. In that, it will be a fundraiser for funeral costs, because I'm not entirely in the loop, but I do believe they want to fly him back to Utah from South Korea. And yeah, so we need to help out. So, hence the link up on top of the chat. Also, this channel will host Jeff's Moddy Christmas, the moderator appreciation stream that Jeff held every Christmas. This year it will be on this channel, and we are trying to fix a time and date for that. Well, okay, let's continue.
22 SC 185220.
Still not Mr. Stillwell's.
Good morning, Mr. Malone. We're here today for case management. Mr. Mackey, where are we on position 4? And then we can move to position 5.
On position 4, we have received discovery and an offer. That case is ready to go to a final plea calendar. And Your Honor, I believe that the
Nicola, I don't know if there is a time and date set yet, but if you want Friday, then Friday it is. And so check Jeff's Discord, the mods own Discord thingy there. And if you want Friday, we'll do Friday.
these are already scheduled for final plea in January.
Yes.
So we're expecting to do that on position number 4.
Yeah, still waiting for when.
All right, position number 5 is indictment 20.
Yeah, this guy has nothing to do with the YSL, who is up there right now. Still waiting for when our guys will be having their day.
I sent Mr. McKeon an email about that. I don't see one yet.
All right, Russell Green.
The state is going to be submitting a malcost on positions 1 and 2.
Mr. Marquez, are you representing the state?
I am, Your Honor. Just so the court is aware, the state is going to be submitting a malcost on positions 1 and 2. I thought we had already done that, but clearly not.
All right, Mr. Green, the state is announcing that they are no longer going to pursue this case against you. And they will be submitting a null process order for the court's consideration. Thank you for showing up this morning. If there's nothing further, you are excused.
Well, that's
Position
one guy
number
who's,
1.
that one guy whose case is solved. No pros. He walks. Don't know who he is. Don't know what his charges were. But cheers to you. Have a good life. Don't do dumb things.
All right, so that case is null process as well.
Thank you, Judge.
Position number 7, indictment 20. For SC 004525, Xavier Warnier.
He's in custody, Your Honor.
Ms. Jones, is that your client?
Yes, Judge.
Mr. Marquez, are you representing the state?
I am, Your Honor.
All right, it's on the calendar for plea and arraignment. So bring out the defendant, please.
Judge, I also filed a motion for bond reduction on that one.
It's not listed on the calendar.
Because she put the calendar out before I filed it.
He has a...
She put these calendars out a long time ago. I filed it,
And Judge, I would, and with all due respect to Ms. Jones, I would ask to have that set on a calendar or a specific calendar so I can bring in the victim. The victim deserves to be here.
I filed it on November 20th. I sent copies of it to everybody.
Does that include?
I'm trying to. Okay, I have all the court streams up, so that might explain why this is.
Mr. Marquez?
Yes, of course it does.
You said everybody. I don't know who that includes.
Well, it includes the relevant parties, Mr. Marquez.
All right, so
and the
Mr.
case manager.
Marquez, Ms. Jones is asserting to the court that she gave you a copy of her notice.
And if she electronically filed it, I don't doubt that at all. The only thing being, Judge, because it's set for a plea and arraignment, not necessarily a bond reduction, that's the only reason that I would ask for a particular date on that.
All right, so let's deal with plea and arraignment, and according to you, Ms. Jones, he already has a bond, correct?
He has a $10,000 bond, but the bond order reads $11,000. So yes, he does have a bond.
All right, as to indictment 24 SC 004525. We're here for plea and arraignment, Ms. Jones. What are we doing?
We'll waive formal arraignment under a plea of not guilty.
All right, so the court will enter a scheduling order. You will be notified of the next court date. Ms. Jones, I'm going to come back for the bond reduction and give Mr. Marquez an opportunity to reach out to the victim. We're going to hear it today. We're just not going to hear it right now.
I hear it today? Okay.
Yes.
I understand. I was just clarifying, Judge. Let me say this as well. There is a non-complex case that should have already been transferred to this courtroom. I'm not sure why they're dragging their heels. That case number is 23 SC 191544.
Non-complex does what it does. Delay, delay, delay.
Well, it was already delayed when I picked up this case, and I've been in communication with them for a while, and I can't figure out why they haven't submitted that. And I'm concerned about that one because that one is a criminal damage to property in the second degree. The discovery I see in the file from the non-complex attorney suggests that it's a misdemeanor at best, and he's been in custody for quite a long time. You've been in custody since May of 2023? Of 2024?
Yes.
He's been in custody since May 29th of 2024.
6 months later.
And then he did some time on that case last
year. On the 24 SC 004525 or on the 23 SC 191544?
He got picked up on the 24 case, Judge.
Okay.
And then he's also being held on that 23 case.
They never set a bond in the 23 case?
He has a bond, and that's been reinstated.
All right, okay.
And Judge, just so the court is aware, and there was an ex parte filed on the 23 case. So it was under judicial hold status for a little bit.
Right, and when I got the file, I met with my client, determined that that request had been made in error. It's been withdrawn, and so it's ready to come here. I'm not really sure what they're waiting for.
All right.
But there's been a lot of dragging their heels on that case.
You can look into that while we wait for Mr. Marquez to speak to the victim.
Okay.
Or have someone in his office speak to the victim.
Thanks.
All right, position number 8, indictment 24 SC 004916, Rodney Jackson. Who's representing the state?
Judge, that's Mr. Wittenauer's case. However, for purposes of this calendar, I'll make the announcement.
All right, so this is on for plea and arraignment.
Yeah, when she says Rodney Jackson, Shannon, I believe that's his middle name.
Ms. Jones, what are we doing?
We're going to waive formal arraignment and a plea of not guilty.
No, that's not
right.
it. That's not Mr. Stillwell's.
The court will notify
For frick's sake.
the parties of the next court date.
Thank you,
The
Judge.
scheduling order will be put in place.
Thank you, Judge.
There's nothing further. All parties are excused. So we're going to move to the final plea calendar, indictment 23 SC 186907. Marquisha Knox.
Judge, she is present today. I'll ask for some time just to go out. Retrieve her.
All right. Let's go to position number 2, indictment 22 SC 185436, Jawan Gaston. I don't see Ms. Rondon, so we'll come back to that. Position number 5, indictment 24 SC 001933, Javion Outlaw.
Good morning, Your Honor. Camera back up. Mr. Outlaw.
Is he present?
He,
Okay.
And Your Honor, this is on for final plea, and we have a negotiated plea. I was in the middle of completing paperwork when Your Honor came on the bench, so if I could finish.
Go ahead.
Okay, thank you, Judge.
That'll give me enough time to go call my victim on that other case.
You ready?
Your Honor, I'm sorry, I still.
Oh, okay, not a problem. We have other cases.
Okay, I now see. Okay, in the remaining of the remaining 5, the defendants have arrived in the courtroom. They are waiting for one attorney. So we are. I am juggling 3 different hearings today, and yeah, I'm still at the learning curve of the EVMux platform, which I'm streaming from, and it's a learning curve, and I'm currently going downhill.
Go to position number 6, indictment 24 SC 001711 Beverly Range. Is Ms. Rondon?
No, little pill. I'm not juggling 3 of my streams.
Okay.
I'm juggling 3 of the streams on the law and crime, on the Judge McBurney's board feed, and law and crime.
Let's try position number 3, indictment 22 SC 185439 Aquila Carter.
Judge, I'm gonna try to get in touch with him. I expect him today.
All right, position number 4, indictment 24 SC 001756 Deshaun Hodge. All right. Mr. Marquez, are you representing the state?
I am, Your Honor.
Okay. Good morning, Mr. Hodge. This is indictment 24 SC 001756. Ms. Jones is present representing Mr. Hodge. Mr. Marquez is representing the state. The calendar reflects we're here for a final plea. What are we doing, Ms. Jones?
Mr. Hodge is going to maintain his not guilty plea, Judge.
All right. Any outstanding issues, Ms. Jones?
Not that I can think of right now, Your Honor.
All right. With that being said, you will be put on a trial calendar and be notified accordingly. If there's nothing further, all parties are excused.
We'll get on with it now so we can hear Shannon Stillwell get released on probation.
All right, let me go back to that.
Judge, can I have 2 minutes to?
Sure.
Thank you, Judge.
I need to fill up my
Is Attorney Lewis
coffee.
present in the courtroom?
I'm sorry, Your Honor.
I'll be right
Lewis.
back. Filling up my coffee.
Okay, all right. Before you arrived, the state announced that on indictment 22 SC 1822988, Janice Dillard, that they are going to null process that case.
Judge, of course you know I have no objection. And it is good to see you. I saw the meeting here and I said, oh, they did you on the bench too. And you told me it was for something else, so.
Of course.
Judge, is it possible to have this matter sealed without a formal motion, or do I need to send that? I can do that.
As long as the state isn't objecting, so you can get with the state.
Okay, I'll do that.
Mr. Marquez just stepped out, but you can send him an email or follow up.
Yes, ma'am.
I don't think it'll be a problem since they're not proceeding.
Yes, ma'am. Sounds good. Thank you, Judge.
All right, there's
My
nothing.
case is being concluded, my client and I be excused.
I was just about to say, unless there's something further, all parties are excused.
Thank you, ma'am.
All right.
Have a great day.
You
Merry
too.
Christmas.
Just trying out the features. Just trying out the features. Oh, folks, I have built-in sound effects.
Deputy Hudson, let me know when something's ready.
I will, Your Honor.
Yay! This is serious matters. I need to stop playing around. Yeah, court audio seems to not be in stereo. So only one way, I only hear it in one of my ears as well.
Oh, there you go.
Thank you, Dave. Oh yeah, let's do that while we... Oh. First, let's see here. Christmas Mullen gifted 5 memberships. Thank you so much. Thank you so much. Nicola Maxwell became a member, and she's also now a mod on this channel. John Commune gifted 5 memberships. Thank you so much. And now Dave also gifted 5 memberships. Yeah. Kayla, yeah, I know. Kayla is showing a different courtroom. She is probably showing this, right? And this here is the Jack Gotti bond hearing. This here is Shannon Stillwell's with the Max Shard is there. We already know that. And over here is the remaining 5. So I'm trying to balance 3 3 of these to make sure we don't miss anything. Okay, so thank you for a grand total of 15 gifted memberships. Thank you so much. Which also means we are at 16 combined. New Viking crew! And we have a split between a split honorary Viking between Christmas Mullen, John Commune, where is it? There. And Dave, with each a combined $15. So yeah, let's get to this because I have. Well, let's see if this is one is closest.
It is today because John.
Judge left the courtroom, so okay. Let's see if anything happened in the Okay, the hearing for the 5 remaining have now started. Okay.
Mr. McMullen, but we have the counsel for everybody else, so we'll just go ahead and get started with the final pleas for those people. Are there any guilty pleas that are going to be tendered today by any of the attorney, via any of the defendants?
Yes, Your Honor. Anastasia Smith on behalf of Mr. Miles Farley. We have a court.
All right, why don't y'all come on up to the podium, please?
Okay, so there are 1 plea agreement. 1. Oh, for frick's sake, stop doing that. Which means we are now down to 4.
All right, Mr. Gotti, whenever you're ready.
It's not my camera that is out of focus, that's the court camera.
And everybody, I'm just going to give a reminder to just use the mics that are in front of you, and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183572, State of Georgia versus Mr. Miles Farley. Mr. Farley, please raise your right hand. You solemnly swear and affirm that the testimony about to give the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir? Yes, sir. Okay, put your hand down. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask you more questions. So 2 things at once.
And Mr. Gotti, maybe reposition the mic while he's doing that.
Yes, Judge. Mr. Farley, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking or under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? And how far have you gone in school? I got a bachelor's degree. And are you able to...
Can you also speak into the mic, please?
26 and got a bachelor's degree. And so are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is the possession of a firearm in the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial. Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to? Yes. And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years. Yes.
Seems like Miles Farley is taking a plea deal.
To that count, the single count.
Well, this is the plea deal for Miles Farley.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, so the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge. Do you have any questions about that? No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Oh, for frick's sake. Yeah. Again, this is the shadiness of the prosecution. As long as they plead guilty to the RICO charge, they're good. But it also means the RICO is, depending on his past, can be severe. But, so one count of RICO. One count of RICO. Not the gang count. But that's what the prosecution are interested in. RICO.
You understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts? Yes. And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else? Yes. Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir? Yes. Do you also understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking the guilty plea here today that you're waiving or giving up all of those rights? Yes. And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? No. And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that it is in your best interest to do so? Yes. And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts
Alford plea, good,
guilty,
good.
Places you in the same position as you're convicted after a jury trial? Yes. Okay.
So,
And how do you plead to count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572?
Guilty on the Alfred.
And Mr. Farley, is this Alfred?
yeah, Alford plea is probably the best possible outcome.
The charge that you're pleading guilty to.
Yes.
And you understand that you may have a limited right to appeal this guilty plea conviction.
Yes.
Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraint that you have to file under those areas of the law.
Yes.
Do you have any questions about that?
No.
Okay.
All right, and your attorney, Mr. Manatas, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am. And just so the record's clear, I just provided to Ms. Persefield the indictment, which was signed by all parties as it relates to the defendant's guilty plea to count one conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt
that still cracks me up that they actually claim they could prove it.
This defendant, Mr. Farley, in conjunction with...
But they have to, for the Alford plea, to get it on the record.
...associate did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. The recommendation as it relates to, or the joint recommendation that the parties would make to the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender treatment, and he is
first offender.
Treat him as a first offender, which the state has no objection to either, and the recommendation would be 5 years to be served on probation.
5 years probation.
All right.
So basically, yeah.
Mr.
So he
Farley,
spent 2.5 years
discuss with you,
in jail
the first
just to get
offender
probation.
and what all that means.
Yes, ma'am.
All right, and have you all discussed
It's-
potential
It is infuriating.
upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon. Understand? All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, Judge, I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat, that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area, his creativity, intelligence, tenacity, his bravery in taking things this far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant.
Oh, he's been on house arrest.
He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. what ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
They didn't have any real special conditions, obviously, other than follow the law.
Okay. All right, well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up and that you are following the law. All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If he would wait, Ms. Jolly is on the way.
All right. Mr. Meneses, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, Your Honor.
All right. Yeah, that'll be fine. And after you meet with her, then you are excused. Thank you. All right. Are there any other guilty pleas that are going to be tendered today? All right. So what I would like to do is...
Okay, so
and we
4
can,
remaining.
Start up here.
4 remaining defendants in the YSL-Trial Part 2, as of
Mr.
now.
Linder, and I'd like the state to put on the record what the plea offer is. And I want everybody, all of the 4 defendants, and Mr. McMullen, we just heard from your attorney, and he believes he will be here by 11:30. He's apparently in Gwinnett County on some other case right now, and we'll have to just sort of wait until he gets here to handle yours. But this applies to you as well, for everybody. This is the final plea date. It's your first final plea before me. I know that y'all had a final plea before Judge Dempsey previously, but I gave you all the opportunity post the verdict in the case with some of the co-defendants to
Yes,
negotiate,
Louis Thomas, they are going to be tried together if this goes to trial.
Final plea date, if you will. But this will be your last opportunity to enter a negotiated plea in this case, meaning you all in the state have agreed to a recommendation, and you can be assured that if I do not accept that recommendation, that you can withdraw your plea. Now, you can obviously at any point in time enter a non-negotiated guilty plea, and that would mean that you decide to plead guilty, and the state will make a recommendation as to sentence. Your attorneys will make a recommendation as to sentence, and it will be entirely up to the court to sentence. Could be above or below what any of the recommendations are. Could be exactly what one of the recommendations is, but as long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, Your Honor.
Okay. All right. So, Mr. Minder, you have this case pending, and you have another case pending as well. Is that right?
And Your Honor, so we were going to respectfully request to hold our announcement and to have an opportunity to approach the court at the bench whenever convenient before we move forward with the final.
All right. So I will come back to y'all. So, Mr. Garlington and Mr. Mondelli and Mr. Abadi, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor.
This will be interesting.
On December 9th, 2024, an offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering a guilty plea. The recommendation from the state was for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it be reduced to the lesser included offense of voluntary manslaughter, and him to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 all parolable time.
All right, and as a part of that plea offer, you all were gonna null cross 40, 42, 43, and 51, is that right?
That's correct, Judge.
All right. All right, and Mr. Mandela, you discussed with
Yeah,
your
for me, it's
client,
quite clear. They can't get
potential
anywhere with the drinks.
sentences that could be
Because
faced,
clearly,
if he goes to
it wasn't
trial and
Shannon
is convicted
who did the
wrongly.
murder, so how could they other be participating?
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account, and fairly often probably sentence in accord with that, but that is certainly not a guarantee. So, Mr. Abadi, would you be able to put on the record another thing as well? I know that there was a not guilty or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. The, I don't know, state's sort of story, theory, if you will, might or might not be the same. And the ultimate outcome might or might not be the same. And I'll tell you, and I'm sure that all of your attorneys have told y'all, that acquittals with a jury are a rarity. So just keep that in mind. It does not mean that the same thing would happen to you. Y'all, you know, we've got
Sadly, she is absolutely correct.
Prosecutor at the table who I hope would stay through the trial of the case.
And some shade at
look
Prosecutor Love.
a lot different. There's also a different judge at the beginning. So just keep that in mind, but I understand that for now y'all will be rejecting that offer. All right.
She's not peering at the camera. She's looking at the prosecution, who is right below the camera.
A motion pending. I will tell, and Mr. Johnson, you should now have all of the transcripts from the main witnesses who testified around the two attempted murder counts at trial. And if we are not having a plea today, I'm obviously we're not going to have that hearing today, but I would be interested in going ahead and getting that scheduled. And I will say that I have heard the testimony as it was presented at the last trial, and I have seen the videos. I don't know what might be presented at the immunity motion, but I'm fairly certain that those two videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just
understood.
Yeah, there are still
understand that as
the
well?
car. Yeah.
Okay.
There's, yeah, as Tracy Fagan says here, the prosecution can't get away from the cars in the drinks murder. They cannot get away from the fact that it's not an infinity. They can't get away from the fact that the gang experts are absolute morons. But there are a lot of trials in this county with similar or even worse evidence, which still gets guilty verdicts. It is a risk. It is a risk.
All right, so Mr. Body, can you put on the record what the offer tendered to Mr. Eppinger was, please?
Yes, Your Honor. The state's offer as it relates to Mr. Eppinger was a global sentence of life imprisonment as it relates to the armed robbery and everything else to run concurrent.
Yeah, Mr. Eppinger.
This indictment, that sentence to run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Eppinger is facing a minimum of a life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Eppinger is facing approximately 15 different felony charges on this indictment. Is that right?
That is correct, Your Honor.
Okay. All right, and if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Eppinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Eppinger?
Yes, Your Honor.
You understand that, Mr. Eppinger? Okay. All right. And was there something else you wanted to say?
Oh, no, I, just based on the circumstances, I came to the podium.
Okay.
To make my announcement. But given the state's offer, Your Honor, at this time we would reject that offer based on our view and our view of the evidence in this particular case.
All right.
So yes, we would reject that matter and like to proceed to trial.
All right. And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right, thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right, not December though.
Let's see here. I've got some questions here. Can they request to be severed from Eppinger? Yes, they can. Don't know if that will be successful, but yes, they can. Dave asks, so we get another trial? Well, in regard to Mr. Eppinger, yeah, it seems like it. So at least one more trial.
Not that soon. Okay. So have we covered everybody other than Mr. Minder at this point? Yes. All right. So let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
State would have no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be
Okay. Well, there are 2 officers who got shot.
Well, actually, there's only one who got shot. There's
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So.
So your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
No, it is related to
Okay.
both, but the other witness is not necessarily important for the
Okay,
motion.
all right, so that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I think two, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay, all right, so let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent, how you're acting in self-defense.
I mean, if he wants, whomever he wants to call, he can call. And I get that, so do you think you'd be calling your client?
Oh, that would be interesting. If he's going for a self-defense defense. It was impossible for him to know that in this particular instance, that it was cops he shot at. Well, unmarked car, not in cop clothes. I don't believe from the video they identified themselves as police officers. Hey, who knows? It will be interesting.
Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client after discussion with him, and it may be a situation where we may just, the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that.
Okay. So let's look at sometime the week of January 13th.
If it's just the video, the state would stipulate to the video coming in, Your Honor, making a.
Okay. All right. Did you? I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right. Let's do 10 a.m. January 13th.
Your Honor, I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay. Just making sure. All right. And then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want one witness, and it would be who we would need in production.
Okay. Okay. Mr. Johnson, and I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Evans.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark. But okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of picking the jury, do y'all want to do jury questionnaires, or do you just want to have people in and do it all live? So, I mean, if this were a typical case, I wouldn't call more than 72, but.
My experience is that they are more comfortable being honest and letting their thoughts come out in the questionnaire.
In the questionnaire. Okay, excuse me.
Yeah, so it seems 4 defendants going to trial unless somebody's asking to be
So I
severed.
know that at least as sort of a pilot project, Jury Services here in Fulton has some, I don't know, tablet type things that jurors can answer the questionnaire electronically, but I think they basically like come in, but just sit and answer the questionnaire, and then we have them back another day for follow-up. So we could do something like that if everybody's amenable to that. Okay, and have y'all thought at all, I guess did y'all already go through at least part of jury selection in this?
We did.
Prior iteration? Some of you did and some of you didn't, right? All right, so, I mean, I would need to know what type questions y'all want. So can y'all by, let's say, January 20th, have the potential questions that you all want asked?
The questionnaire was sufficient, but it was redundant.
Well, we don't want redundancy. I'm not a fan. Well, redundancy every once in a while is a good idea, but I want to be efficient. Okay, so I'll pull and look at the last questionnaire, and if, y'all do the same, and if there are ones that you think we can strike, and any that you think we need to add, if y'all can just let me know that, and maybe we'll have, let's look and see what the 20th looks like. Maybe we can have, the 20th is the MLK holiday, so let's not do it that day. Let's do the 17th, which is the Friday before. Why don't we plan to just have like a status on, let's say 10 a.m. on the 17th of January, where we can, so if y'all would submit whatever kind of additions, deletions you would like to the jury questionnaire by close of business on the 16th. We'll meet on the 17th for a status. And
Judge, that everyone in this courtroom on 17th?
everyone who is still wanting to proceed to trial at that point in time. And in addition, Mr. Dark. And then I know the state had proposed, did y'all say February 24th as the beginning of trial?
Yes.
I had been thinking, I mean, is that a trial day for us? We can.
Make it one, but
I'll speak in Mr. Dark's place. He had sent an email after I filed my motion. Apparently he may have leave filed on that day.
Let's find out whether he does.
Okay, so February 24th, May. Okay, I think that's the date Judge Whittaker said last hearing.
Anybody else have any kind of an already filed conflict with beginning trial that day? Okay. Is it already filed? Okay.
But things can be rescheduled, so that's not an issue.
All right.
Does the court expect to have jury filling out questionnaires prior to the day that we're starting?
I mean,
There's a couple things that can happen.
yeah.
One is the questionnaire, and we can start by the table, it might be more efficient, but the questionnaires give rise for certain clauses. So if we can agree to ones that are clear, then we can at least dwindle down and not have to waste time on whether or not.
People who are clearly going to be stricken for cause.
Right. And I think those things, like, they can get the questionnaires done, we can.
Yeah, I mean, I definitely think we need to get the questionnaires back before we have them back for the, day of actual questioning, or days, I don't know, of actual questioning. So.
Reading of the indictment is a day of us sitting there, or was a day,
Uh-huh.
multiple days.
Let's see what we can.
I mean, it may be that the state's not intending to go forward with however many overt acts it was before, 213 or something.
Likely.
They may winnow down the indictment. Could you have that done before the 16th as well, or by close of business on the 16th? Okay. And I was going to say there's no reason to read the substantive counts that are against defendants other than these 4 or whomever it ends up being. But they may be overt acts anyway, but we wouldn't need to read the counts, even if they were included as overt acts. So it would be a redacted indictment that we read. But yeah, we'll talk in more detail on the 16th, on the 17th about that, about, what date we're going to have jurors in, how many jurors we think we need to call, things like that. Okay. And then I know there are no, other than the immunity motion, no outstanding motions, but are there going to be motions in limine, evidentiary kind of things that have not already been resolved? I need y'all to think about that and get all of those filed by January 16th as well. Okay. Actually, if y'all could get those filed by the 15th, that would be good, and then I could be taking the 16th to start looking at them, and maybe we could talk through some of them on the 17th.
Can we have a deadline for a discovery Dropbox link?
I would sincerely hope that all the discovery has been shared by now.
I know they're working on consolidating some of the new stuff that came out as it relates to during the trial.
Okay.
But that shouldn't take very long. I know Mr. Dark has received the majority of, it's just taken a minute, over 8 terabytes file for Mr. Dark, so that's been the focus. But I will make sure.
Yeah, so if you, the state, could put together your narrowed, cold, focused discovery.
Yes.
Can you get that? When do you think you could get that to all the defendants? Because even if they have everything, they'd probably rather have the smaller universe of things.
The first week of January, is that
Sure. Yeah, that works. All right, so that would be, find my calendar again. January 3rd. By close of business, January 3rd.
Yeah.
All right, anything else?
Still terabytes of discovery.
All right, everybody else, I'm going to go ahead and release.
Yeah, there are still terabytes of discovery in this case, even after the previous trial, and now with only 4 people in it. And I would assume there will be some filings from the defense about things they believe should be in discovery. I'm thinking of the McDonald's surveillance video, of course. I'm also interested in the laundromat incident, surveillance from that one. I would be and also the hospital report. So I would assume there will be some filings from the defense as well regarding, because it's a new trial, it's a new judge, and then motions in limine regarding testimony and evidence. I assume that. I don't know. I don't know. I can't be sure. Would I? Oh, hell yeah. But I'm not their lawyer.
Mr. Abadi, obviously you'll need to stick around, and we had an anticipated 11:30 arrival time for Mr. Dark, so we'll hold on to Mr. McMullen as well, and then once we have Mr. Dark, we'll reconvene for his final plea and to discuss with him the deadlines we've set. Was there something else, Ms. Fagan? Oh, sure, yes, I'm sorry, you did mention that.
All right, this will now resume at 11:30. But I expect it to be no different. Finally, we can get over to Judge Burnley's office, court cam, I believe. Let's see here. For the Jack Gotti thing. And let's see what happens here. Oh, this one.
Mr. Rao, are you handling this, or do we need Mr. Abate back? You're handling, okay. Let's get one thing up here on the screen. All right, Ms. Rivers, are you ready?
Yes.
Okay, this is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick.
How you doing?
I'm all right. How are you doing? I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these two cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll.
Yeah, so this, what he is, the contraband. He had some earbuds and a phone. Jesus Christ.
You'll hear from me when you're ready.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to be given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions granted, given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working for, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, you know, our typical, you know, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, and I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot, it's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and he'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level. And basically for his own safety. You're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place. And the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Kayla did a good argument.
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation and then I'll get the warrant out to.
He has a. Okay, this is new to me. I didn't know he had a warrant. Whoa. Okay. Oh, this is bad. This is bad. It's stupid. Because what happened in jail should not be an issue anymore, since not guilty. And what was it? AirPods and a phone? That's stupid. But if he has a warrant on top of that, yeah, that complicates things. Jesus Christ, 2.5 years in jail, not guilty in the trial. Oh, God, no.
Everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged.
He was assaulted.
Alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing
government overreach.
Essentially a vicious beating and assault on a fellow inmate, Pretrial Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's, co-defendant Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case.
I can almost guarantee that is what the sheriff's office says about all the co-defendants. But folks, this looks bad.
Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Hansberry.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentence, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3.
It sounds bad, but still going back to the YSL trial, it's probably all complete bullshit. Complete bullshit. But they're in front of this judge, and this sounds quite bad, folks. So I don't know what's going to happen here. But I'm quite sure everything this prosecutor is telling the judge is complete and utter bullshit.
Are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk.
This is the exact same crap these bastards did in the hearings leading up to the YSL trial. And then we saw the actual evidence, and it was utter bullshit. And I assume it's the same kind of crap this time. They just want to keep him in jail. That's it. Even though a jury acquitted him of all charges, they still... This is revenge, folks. This is the prosecution's revenge, prolonging his jail time. Jesus Christ.
To reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
He wasn't
in
the
house. Do you
house.
have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the two cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations.
So the warrant is for bullshit. Now, this is... Yeah, oh, thank you, Lil Pill. Thank you. Isn't one of these incidents one that Judge Whitaker said appeared to be self-defense and denied bringing it into the case? You're absolutely correct. Thank you for reminding me. Yeah, the assault where you heard his description of the events. Yeah, Judge Whitaker denied it getting into the trial, into the case. So, yeah, This Assistant District Attorney fuckfart is a liar. Probably knows it. But this is what the Fulton County prosecutions, the Fulton County District Attorney's Office do. They lie. They lie, 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 and lie again. It's infuriating. And they get away with it.
Or it would be something in aggravation at a bond hearing or at a sentencing hearing.
That's
is your
correct.
best forecast, with maybe one exception.
That's correct.
Okay. All right.
Thank you, Judge.
Thank you. Ms. Plumpus, want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that, because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey,
yeah. The state, lo and behold, tried to make a chicken out of a feather. Just in court embellishing.
Report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case.
This is the judge telling the prosecution to, you need to knock that shit off and bring something to conclude this matter. Now, they don't have to follow his suggestion, but it's a good idea to actually do it. But I say that what that prosecutor stated here in court, probably all BS. All BS.
You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these two cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these two cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these two cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state?
Yeah.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
It does sound like the judge already made determination regarding bond, and it's positive. But the government overreach here. Not until the day of the hearing in front of the judge, they bring up this old warrant. It's so disgusting, ethically wrong, but they get away with it. That's why they are doing it. This is pure revenge from the prosecution side. Luckily, it seems like Judge McBurney just told the prosecution to knock it off, resolve it, and let's move on. Oh, pissing me off. So, Jack Gotti will remain in jail until this is resolved, even though he was acquitted at trial. He still has to be in jail. All right. Let's now go to Mr. Stillwell's. Ow! Ow! Or is that not? Wasn't that streamed? Okay. That it seems like they cut out the 11 alive. Let's check in on X. See the resolvement here. Okay, I have it here. I have it here. I have it here. Let's have this instead. Shannon Stillwell has accepted a plea for the rest of his lingering charges. Granted time served on everything, and he will officially be a free man today. And Shannon essentially received 12 years probation on these charges. Shannon is also banished from the Metro Atlanta area. Probation runs concurrent with his sentence from the RICO case, so no extra probation. Judge took it upon himself to banish him from Atlanta for only 5 years. Whew. Okay, so Shannon Stillwell, if everything was resolved today, he's on probation. I don't know if he's allowed to leave Georgia, but if he is, I am assuming he's headed for Texas for the long-awaited honeymoon with Kayla Bumpus. So for the newlyweds, congratulations. For I hope you live a long and happy life, successful life. For Mr. Kendricks, Jack Gotti, it's disgusting. It's extremely disgusting that you have to remain in jail for a bit longer. I assume it is because the prosecution wants to get that into a plea deal as well. Or they will remain him in. It's so disgusting. It's so utterly, utterly disgusting. But I hope it will resolve soon. In the remaining trial, the YSL-Trial Part 2, we are now down to 4 remaining defendants. Hello, Mr. Jingles. We are now down to 4 remaining defendants. After Miles Farley took an Alford plea to count 1, the RICO charge, and got 5 years probation. So he has spent since the indictment. He was granted bond, so he's been on house arrest with all those restrictions. Now he will be under probational restrictions, which is much easier on him. And I hoped for a much better day. Well, for Shannon Stillwell, it seems to be a good day. For Jack Gotti, could be worse. The judge could have said, yeah, no bond, but he didn't. He had to table the situation until this warrant situation solved. But it sounded like he was open for bond. That's what it sounded like. And we got confirmation that the Fulton County District Attorney's Office are all bastards. Lying bastards. Yes, are there people in the DA's office who are less of bastards, who lies not as much? Yeah, maybe. I don't care. They choose to work there under DA Fani Willis. Lying, adulteress Fani Willis. Liar in church, liar in court. Now, yesterday I started with what's going on with Fani Willis. It got abruptly intervened with something more important for me personally. I will continue that coverage tomorrow. Oh, I will continue that coverage tomorrow. And yeah, but that concludes. Well, hold on. The Mr. Jingles Advent Calendar Snacks. Let's go with that. Let's go with that first. Yes. Yes. Yes, Mr. Jingles. You will get your snacks. You will get your snacks. You will get your snacks. Nom 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 nom. Nom 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 nom. There. Mr. Jingles needs his snacks. All right, everybody. That concludes today. Please go look at the pinned link on the top of the chat on YouTube. Go over there and subscribe to Jeff Legal Vices, who sadly passed away Sunday. Did I check back on Whitaker? Oh, they are still not back. Oh, wait. No, still not back. So I don't know. If anything surprising happens, I will do a video on it. I will do a video on it. Thank you, Little Pill, for reminding me. But that concludes today, folks. That concludes today. And let's get Jeff's channel up to 100,000 subscribers so his family can receive the play button that Jeff fought so hard to get. Yesterday, Jeff had 84, if I remember correctly, he had 84 point something. Let's check how he is today. Dun, dun, dun. He was at 84.4. He is currently at 86.7. 86.7. So it is going up there. This channel will host Jeff's moderator's Moddy Christmas stream. His appreciation for his moderators. Since, it needs to be done. So as soon as his moderators give me a time and a date, I will let you all know. Okay, folks, thank you. And a reminder to hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Thank you all for showing up, and I'll see you back here tomorrow. Bye-bye.
In a snowy land where the dragons once roamed, a Viking and a cat make a cheerful home. Mr. Jingle purrs as he hangs the lights on.
Oh, silly me. Thank you to Christmas Mullen for your gifted memberships. Thank you to John Commune for your gifted memberships. Thank you to Dave for your gifted memberships. And of course, TST. Thank you for your 20 gifted memberships, who also gave you the honorary Viking for today with a combined $60 in support of this channel. Thank you. All right. Now I'm done. See ya. Bye-bye.
In a snowy land where the dragons once roamed, a Viking and a cat make a cheerful home. Mr. Jingle purrs as he hangs the lights so bright. Together they bring warmth through a frosty night. Garlands wrapped around the many wood beams, Viking hymns will tune hold tight till